Ending a contract. I have spent a lot of time talking about the requirements for the creation of a contract and for the formation of a binding agreement between the parties. I have discussed in another podcast the situations in which a contract may come to an end through breach, or may be deemed never to have come into existence by virtue of misrepresentation and rescission. In this podcast, I will discuss two other ways in which a contract may end: performance and an agreement to terminate. The perfected performance of a contract is probably the most obvious way of bringing it to an end. I hand over my money, you hand me my cup of tea, and the contract is performed. And in many simple contracts, that is all there is to it. Some agreements cannot be characterised by a simple, immediate exchange constituting full performance. In particular, a services contract may be ongoing, in the sense that once it has begun, it continues until one of the parties terminates. Consider the provision of phone service, for example. The contract may have an initial fixed term of, say, 12 months, but many agreements will provide that the service continues to run after that period until one of the parties cancels. In such a situation, the parties are likely to have agreed provisions covering contractual termination. Commonly, this will include a period of notice from one party to the other, after which the contract terminates. When you're drafting a termination clause in a contract, you probably want to be mindful of a number of different things. Firstly, the circumstances of termination. Can the parties terminate at any time? Do they have to wait a certain period? Is there an initial term for the agreement, or can they terminate as soon as they wish? Can they give termination over the phone, or does termination have to be put in writing for certainty? When is notice effective? Is it effective immediately? Does termination happen instantaneously? Or is there a requirement to give 30 days notice of termination, for example? Does there have to be a basis for termination? Can you terminate for any reason at all, or does it have to be linked to unsatisfactory performance? My feeling is that in an initial period, you may be able to legitimately require that termination, if possible at all, is only for cause. But if you have a services contract that's ongoing, requiring that it can only ever be terminated for cause implies that as long as one party continues to deliver, the other party can never terminate, and I would be very surprised if a court would uphold a contractual obligation that purports to be perennial. Secondly, you'll want to think about what happens on termination. In some cases, termination may be the end of the parties' obligations to each other. However, particularly for the more complicated contracts, this is often not the case. For example, in the context of the procurement of some software, along with a service and maintenance agreement, does termination of the maintenance agreement mean that you no longer have the right to use the software? Does your license cease at that point? Or do you require ongoing licenses? How are you going to ensure that that is reflected in the contract? Where you have an ongoing service agreement, let's take the example of a web service agreement for the provision of hosting services, you'll probably want to give some thought as to what should happen in the event of termination in terms of winding down. Can, on receipt of notice of termination, the supplier simply wipe the server and take it offline? Does there need to be a documented process for ending the deal, or is the obligation on the customer, you, to make sure that you have downloaded all the data that you require before you issue your letter of termination to ensure that you have what you needed? What's going to happen in the circumstance where you have exchanged items or given items to the other party to enable them to perform their obligations under the contract? If you've given the supplier hardware security devices or laptops, for example, how are you going to make sure that you get them back? For simple contracts, you may never have to think about these things. But for ongoing agreements, particularly those that entail working together for a prolonged period of time or providing infrastructure from one party to another to enable them to perform their obligations, you'll probably want to give considerable thought to this kind of thing up front to ensure that the contract reflects what needs to happen on termination, to avoid the situation that when you do actually terminate, there is suddenly a frantic scurrying to try and work out how you can get the other party to do what it is that you need them to do.